Chapter 3, Professional Ethics, Legal and Regulatory Issues. This is the narrated PowerPoint representing Chapter 3. We will review and define ethics in legal terms and explain how they differ, differentiate ethics and bioethics, describe the types of consent used in healthcare settings, including informed and implied consent, describe how to avoid litigation as it relates to blood collection, define the standard of care in HIPAA, identify key elements of HIPAA, list key factors common to healthcare insurance policies, list common issues in lawsuits against healthcare providers, and explain the term liability and what it means for the healthcare provider as well. So law versus ethics. Laws are societal rules or regulations that are advisable or obligatory to observe. For example, a law that we see commonly is a speed limit. It's a law in place that we adhere to for safety. Laws protect the welfare and safety of society, resolve conflicts in an orderly and nonviolent manner, and consistently evolve in accordance with an increasing pluralistic society. So ethics are moral standards or behaviors or conduct that are governed in an individual's actions. So, for example, all healthcare providers are confronted daily with professional choices. Choosing one type of needle instead of another and using a cleaning agent that creates an allergy in a patient or procedures that can be harmful can impact both the patient and the healthcare worker. When a healthcare worker makes an error, he or she must try to redeem the error and learn from it. So it is a kind of set moral standards. For example, as phlebotomists, we do no harm intentionally. Where bioethics, bio referring to life, are the moral issues or problems that have resulted because of modern medicine, clinical research, and or technology. So your book on page 85 gives the example of life and death issues such as abortion, harvesting embryos, cloning, and also who receives organ donations would be how we differentiate between ethics and bioethics. Ethics being more moral standards, where bioethics are moral issues or problems that have resulted because of advances in medicine. So there's the ethical check. So the ethical check is it legal? Does it comply with institutional policy? Does it foster a win-win situation with the patient or supervisor or other individuals? How would I feel about myself if I read about this decision in the newspaper? How would my family feel? Can I live with myself after making this decision, and is it right? These are things that is a simple check yourself to evaluate difficult situations. There is an example in box 3.1, example of ethical behavior for a healthcare worker that I would like you to review. Patients' rights. All members of the healthcare team recognize that their first responsibility is of their patient's health, safety, and personal dignity. The American Hospital Association Patients' Bill of Rights titled Patient Care Partnership in 1973. The key elements involve a patient's key elements include quality health care, the clean healthcare environment, patient's role in his or her own care, privacy rights, and availability of assistance when leaving the hospital or with billing issues. So, for example, when we're looking at privacy rights, the patient has the right to confidentiality of their lab reports. They have a role in their own healthcare, so we present to the patient the diagnosis and the potential treatments, giving the patient an option to be part of his or her own care and make those decisions. The National Patient Safety Goal. The Joint Commission is an independent non-governmental agency that provides standards for the objective evaluation process that guides healthcare facilities to measure, assess, and improve performance for patient care and safety. So the identify patients correctly is under the goal, use at least 2 ways to identify patients when providing laboratory, pre-analytical, analytical, and post-analytical procedures. Improve staff communication. Provide test results to the right person in a timely manner for critical test results. The results need to be expedited to the physician to diagnose and treat the patient promptly and prevent infection. Use of hand cleaning guidelines designated by CDC and WHO, and set and use of goals for improving hand cleaning. The Joint Commission also adds in the fact that in these agencies, healthcare institutions must undergo on-site evaluations by a survey team every 2 to 3 years, and it's a regulatory body that makes sure that they're upholding the patient safety goals. So there's governmental laws. So there's the legislative branch. I'm going to zoom in here. Written laws are called statutes and are made at the federal, state, and county levels. Executive branch makes administrative laws, and the judicial branch establishes case law based on legal cases from lower level judicial branches. It covers just a brief overview of this in your textbook. Basic legal principle: the laws governing medicine and medical ethics complement and overlap one another. Healthcare consumers and patients have become more aware, more critical, and much more willing to sue anyone that their lawyer believes has been at fault, including healthcare workers who are collecting blood samples. The following factors must be considered in an alleged negligence case. So there is quite a few key terms that I want you to review. So negligence is very important to the healthcare providers. Negligence is a violation of a duty to exercise reasonable skill and care in performing a task. And a tort or civil wrongs that include negligence and malpractice. On page 88, box 3/2, and page 89, there's several legal terminology terms that I'd like you to review. We'll be covering some briefly in this PowerPoint, but this is a chart that you will need to reference to. So there is a duty of the healthcare provider, and that duty relates to those duties or responsibilities the hospital healthcare provider has toward the patient. It also includes all the individuals who had a duty toward the patient to use the appropriate standard of care. The breach of duty relates to whether the duty was breached and if the breach was avoidable. The plaintiff must be able to show what actually happened and what the defendant acted unreasonably. And then foreseeability relates to the concept that certain events may reasonably be expected to cause specific results. For example, using a large needle to collect blood from an older patient with frail veins will foreseeably lead to vein damage and accumulation of blood in the skin around the venipuncture site. The following factors must be considered again in a alleged negligence case. Proximate causation relates to whether the breach of duty actually contributed to the cause of injury, also concerns all parties involved contributing alleged injury or harm. The demonstration that an actual physical injury occurred, as an example, the healthcare worker collecting blood from the patient, the needle went through the vein into the median nerve, and the patient lost use of their fingers and hand due to nerve damage. And the damages, the actual injury and the amount of money awarded to the plaintiff that's based on compensation for the injury, pain and suffering, loss of work, or permanent disability. So some other legal terms we'll cover is malpractice is improper or unlawful care of a patient by a member of the healthcare team, any professional misconduct or unreasonable lack of skill. Then there's negligence, a violation of the duty to exercise reasonable skill and care in performing a task. Please be aware that for malpractice, for a plaintiff to collect damages in the court of law, the plaintiff's attorney must show the healthcare provider owed the patient a duty and that the provider's violation of standard practice caused the patient's injury. There's a couple other key terms. I want you to review all of them. Also being aware of respondent superior. Under this concept, supervisors and directors may be held liable for the negligent actions of their employees. So, for example, if we start taking pictures of patients' test results or we take a picture of patients' charts, our supervisors might be responsible for our negligent actions. Also review the legal terms for assault and battery and understand examples that relates to these terms as well to understand the difference between them. We're going to move on to the Health Insurance Portability and Accountability Act, or HIPAA. It's created legal requirements for protection, security, and appropriate sharing of patients' personal health information. Use of electronic transfer of patients' medical information is a major part of HIPAA. So for HIPAA, we need the patient's written consent. So they need to sign a document. Healthcare workers' confidentiality and non-disclosure agreements. Maintain the confidentiality of all patients' information, computer passwords secure from others' knowledge. Maintain the confidentiality of patients' information when looking at a computer database of patients' medical records and information. Patient confidentiality materials include communication between the physician and the patient's verbal statements and medical computer entries on patients, and nonverbal communication such as laboratory test results. Your book on page 90 goes and provides some examples of innocent activities that could lead to lawsuits, including discussing patient information with the patient's family member without the patient's permission, throwing laboratory test results in the regular trash, and not logging off your computer after entering blood collection updates, sending a patient's laboratory test to be printed and forgetting to take it off the printer, forgetting to clear phone numbers from faxes and computers, and using a personal cell phone when involved in patient's collection, and using a cell phone to take a photo of the patient and patient's blood collection without their permission. Patient confidentiality is again maintaining those materials, so conversations with the physician, verbal statements, making sure that those are kept private. Please also reference the clinical alert on page 91. Confidentiality in HIV exposure. If exposure to blood occurs through a needle, stick, lancet, or other means, the home health care worker needs to be certain of obtaining the patient's HIV status and other potentially infectious diseases to ensure proper, immediate, and long-term self-protective procedural steps can be taken. State law regarding confidentiality in HIV status actually varies state to state. If employed by a healthcare facility, the healthcare worker should follow the guidelines established by the facility. The healthcare worker is self-employed, it is important to monitor his or her own HIV status, and counseling should be sought if exposed. Standard of care. All healthcare workers must conform to a specific standard of care to protect the patients. Examples of setting standard of care statutes, licensing requirements, rules, and regulations of regulatory or professional organizations. This can be found on page 91 and 92 in your textbook. It is also regulated by the American Hospital Association and the Joint Commission. The standard of care is conformed to a specific standard to protect patients. And also, too, it is something we go back to, for example, licensing requirements. So as phlebotomists, we're required to be certified. So there are certifying requirements that we've met certain standards prior to collecting blood on a patient on our own. Informed consent is a voluntary permission given by a patient to allow touching, examination, and/or treatment by healthcare providers. It allows patients to determine what will be performed on or to their bodies. So voluntary permission, again, as shown here, will provide a document which requires a signature for approval. We could also request documentation as an important aspect of informed consent, especially if we are doing any type of research that requires us to draw blood and they become part of more of a research subject. We do need to get that informed consent for research purposes as well. Institutional research boards, IRBs, ensure that human subjects do not bear any appropriate risk and consent to document. They need a full disclosure, describe the level of confidentiality of the research data, and describe the measures that the researchers will take to ensure that it is maintained. Implied consent occurs when the patient's nonverbal behavior indicates agreement. So a patient in phlebotomy could give informed consent. They can sign a document stating that they understand the procedure, all aspects, and they're going forward with the circumstances. There's also implied consent in phlebotomy, and the patient may also give consent for a venipuncture procedure through the actions of holding out his or her arm, rolling up his sleeve, or simply turning the arm in the correct position for blood collection procedures. So there is two ways to obtain consent from a patient. We can either get a written consent or the nonverbal or implied consent. This also implied consent exists when immediate action is required to save a patient's life or to prevent permanent impairment of the patient's health. Implied consent differs legally from one state to another. On page 93, it goes into more detail on implied consent. In an emergency situation, if the patient is non-responsive, it is implied consent that they want to be treated. If they are unable to provide us that consent either verbally or writtenly. Statute of Limitations, it's a law that defines how soon after an injury due to malpractice a patient must file a lawsuit or be forever barred from doing so. This section is a brief overview. As phlebotomists, we just need to be aware of the legal claims and defense. So steps in malpractice lawsuit, there is discovery, which means to examine the witness before the trial. It's a method used to enable plaintiff and defendant to learn more regarding the nature and substance of each other's case. Deposition is the testimony of a witness that's been recorded in written legal format. There's an expert witness. Expert witness may assist a plaintiff in proving the wrongful act of a defendant, may assist a defendant in refuting such evidence. So, for example, an expert witness may testify each expert's training, experience, and special qualifications to the jury. So, for example, in the Netflix special Making a Murder, they had an expert witness who gave testimony to the EDTA tube that was drawn from Avery. So that would be an example of an expert witness in the field. Legal claims and defense evidence, compliant, relevant, and important. Examples include vacuum tube holders, the Joint Commission standards, and phlebotomy safety devices. Please reference the table 3/1 lawsuit prevention tips for minimizing risk, just to review. As I talked about before, respondent superior, let the master answer. It's a legal doctrine that holds employers responsible for the acts of employees within the scope of the employments. So, for example, not only the injured party sue the employee directly, but the employer, if sued, may also seek indemnification from the employee. And indemnification is compensation for financial loss suffered from the employee's act. So there's been legal cases related to clinical laboratory activities. This can be found on page 96 through 97 in your textbook. It goes into great detail. Patient falling, hematoma or hemorrhage, abscess or other infection and injuries from fainting are some examples. Some examples that your book gives is that, for example, the healthcare worker collecting a bedside glucose result misread the glucometer and caused the death of 3 patients with diabetes. The error might have been avoided with better training, supervision, and quality monitoring. Nerve damage, complication from collecting blood from a mastectomy side, complication in blood collection from obese patient, and wristband or identification errors. So an example of this is phlebotomist collected blood from an excessive angle of needle insertion greater than 30 degrees. As stated in the standard care policy, is an acceptable limit from the patient's basilic vein, which is high risk, resulting in median cubital vein was clearly an option for collection, so the blood collection resulted in injury to the patient's median nerve in the malpractice lawsuit. In addition, documented errors were evident for the collection, and all the patient was awarded thousands of dollars from a healthcare worker's violation regarding proper care. So, for example, when we're looking at our selection for veins, we want to avoid the most risky, which would be the basilic, and that's part of our standard of care. There's also one I want to reference back to about patient falling. The healthcare worker knew that the patient had a history of fainting. They took no precautions to avoid the possibility of patient fainting, collected the patient's blood, and allowed the patient to leave immediately. The patient fainted in the elevator and suffered permanent loss of smell and permanent ringing sound in their ear due to the fall. These are situations where the patient fall and injuries from fainting, there's foreseeability. The technician knew the patient had a history of fainting, but did not do any follow-up to prevent it. And again, all of these examples of past lawsuits are, again, completely preventable and can be avoided. So examples of past phlebotomy lawsuit: venipuncture performed without proper training, failure to take precautions to avoid patient syncope, as we talked about previously, patient death caused by misread glucometer results, and improper blood collection resulting in nerve damage to the patient. So in all of these, they give an example in your textbook. Please make sure to read those examples because it's critical to understanding why there was a lawsuit present. HIV-related issues: the healthcare worker must demonstrate a causal connection between his or her HIV infection and his or her employment. Includes having documented incident report at a healthcare facility involving a needle stick injury or puncture wound and other exposures to HIV, contaminated blood, or bodily fluids. The healthcare worker's lifestyle will be investigated to determine whether the exposure occurred elsewhere, and pre-employment health evaluations are used. Employers are legally responsible for monitoring post-exposure follow-up. Professional liability insurance: often the healthcare staff in the hospital or clinical laboratory is part of the professional liability insurance policy. It's increased legal exposure for allied health and nursing professionals in case of an injury or a lawsuit. Just some things examine for personal professional liability insurance. Does the employer carry liability insurance? Is it an adequate dollar amount and coverage limitations? This protects the healthcare worker in cases where there is a lawsuit in place, that there is coverage in case of legal exposure. And also, too, it provides a kind of coverage for attorney's fees. Court costs is usually covered. Liability insurance depends upon the state. So again, you're going to examine this liability insurance procedures that must be followed by the policy coverage lawyer's best interest at heart. Is the job change expected soon and specimen collecting provided offsite or in the patient's home? Are you covered under those circumstances? CLIA regulates and ensures the quality and assurance of laboratory testing. It essentially applies to every clinical laboratory testing facility in the United States and requires laboratory certification by the federal government. There's also on page 99 clinical regulatory regulations by the FDA, Food and Drug Administration, Centers for Medicaid and Medicare Services, CMS, and then also physician office laboratories, as well as American Association of Blood Banks, the Joint Commission, and CAP and ASCP. Clinical Laboratory Improvement Amendment. So for moderate complexity or high complexity testing, the inspection considers all procedural steps in laboratory testing, pre-analytical, analytical, and post-analytical. So wave tests are the easiest to perform, less susceptible to error, and least risky to the patient. So urinalysis, blood glucose screenings are not required to undergo these inspections. Some states, including California and New York, have licensing regulations and testing requirements that vary according to technical responsibility. Phlebotomists are allowed to perform point-of-care tests in some states and not others. The other thing is in complexity, there's what we discussed in the last slide, which was wave test. There's also tests of moderate complexity, and those are tests that are simple to perform but may involve more risk to the patient if the results are inaccurate. So examples include white and red blood cell counts, hemoglobin, blood chemistry, and urine cultures. And tests of high complexity are those tests that are complex to perform and may allow for a reasonable risk of harm to the patient if the results are inaccurate. These include tests that require sophisticated instruments at a pathologist or doctoral level scientist. So for example, examples include bone marrow evaluation, electrophoresis. So just gives you some breakdown to this components. This concludes Chapter 3, Narrated PowerPoint. Please make sure to view the study questions as well as the case studies in action and practice at the end of the chapter to prepare for the chapter test.